Ingrid wasn't just murdered. Her body was brutally discarded. She fought to live. You forced her to die.
That you be put to death by having electrical currents pass through your body in such amounts and frequency until you are rendered dead.
Shame on the federal government. He's being made a murderer from my perspective, the realistic perspective of Trump.
In January 1984, a string of brutal hammer attacks shocked Colorado. On January 10th, 50-year-old Patricia Smith was raped and killed inside her Lakewood home. Just 6 days later, in Aurora, Bruce and Deborah Bennett and their daughter Melissa were found murdered in their home, while their younger daughter survived an assault. Though the cases remained unsolved for decades, investigators believe they were connected due to the similarities in the attacks. Years later, in 2018, a DNA breakthrough linked the crimes to Alex Christopher Ewing, who was already serving a 110-year sentence in Nevada for an unrelated assault. After fighting extradition for nearly 2 years, Ewing was finally brought to Colorado in 2020 to face charges.
Count number 1, murder in the first degree.
During his court appearances, he waived his right to a preliminary hearing as emotional family members of the victims looked on.
So, Mr. Ewing, you understand you have a right to a preliminary hearing within 35 days of today's date?
Yes, ma'am.
Do you have any questions about your right to a preliminary hearing?
No.
And is it your choice today to waive your right to a preliminary hearing within 35 days?
Yes.
Is it your free and voluntary decision?
Yes.
Thank you.
Thank you.
In 2021, he was convicted of murdering the Bennett family and sentenced to 3 consecutive life terms. The following year, he stood trial for Patricia Smith's murder and was again found guilty, receiving another life sentence. In 1986, Angel McCormick was tragically shot and killed inside a Jacksonville laundromat by Kenneth Hartley, reportedly because she refused his advances. Though witnesses identified him and he was charged with her murder, Hartley ultimately accepted a plea deal for manslaughter. He received a 10-year sentence, but was released after just 4 years. During that time, Angel's family had to navigate life without her, while her daughter was raised by her grandmother, Rosemary Wilson. Less than 3 months after his early release, Hartley struck again. In 1991, Gino Mayhew was found dead in his vehicle near an elementary school.
It's a problem, it's a sociological problem, but it's also an economic problem. The state faces tremendous budget constraints and they have to deal with the problem within their resources.
Authorities linked Hartley to the murder, kidnapping, and robbery. The motive was reportedly drug-related.
Circumstance is because under the law of Florida. Lead any witnesses to that robbery. He wanted no one to be able to report that he committed that robbery. He didn't want to leave anyone that would talk, like he told Ronald Ronald, and to apply that test. The state does not seek the death penalty.
That you be put to death by having electrical currents pass through your body in such amounts and frequency until you are rendered dead.
He was convicted in 1993 and sentenced to death. The sentencing judge emphasized Hartley's violent history, calling him a danger to society.
69 days after his early prison release, Hartley committed the kidnapping, robbery, and first-degree murder of 17-year-old Gino Mayhew.
I'm angry with Hartley for what he did, but I'm angry with the parole board because I believe they are the cause of Gino's death.
He killed my 15-year-old daughter in 1986, somebody that he hardly knew, only because she wouldn't date him. And then they let him out early 4 years later, and he killed another teenager. But now he'll never hurt anybody again.
I'm just really happy. These are tears of joy, you know. And like they say, forever sweethearts. I always keep her in my heart, you know, always.
Now, decades later, questions surrounding the reliability of jailhouse informants and the lack of physical evidence have reignited scrutiny into Hartley's case, with his defense team pushing for a new evidentiary hearing. On April 26, 2025, a troubling incident occurred near 17th Avenue and Stockton Boulevard in Sacramento. A 49-year-old homeless woman who was resting in the area suffered serious injuries after being doused with a liquid and set on fire. Nearby witnesses quickly intervened, helping to put out the flames and calling for emergency help. Surveillance footage from the scene reportedly showed a woman arriving in a vehicle, carrying out the act, and briefly returning afterward before driving away. The victim, after receiving medical care and regaining the ability to speak, identified 34-year-old Jacqueline Pop Ibara as the person responsible. Several bystanders also confirmed her involvement, according to investigators.
Fire, oh my God. That's to the point of excessive. Just the idea that you could be sleeping and somebody could come along and, have a problem with you from days ago and just throw something on you and light you on fire is horrifying.
Pop Ibara, who lives near the area, was arrested shortly after the incident. She was charged with attempted murder, aggravated mayhem, and other related offenses.
Luckily, there were about 4 or 5 others there that were able to put the fire out. Disturbing part is Jacqueline doesn't leave. She goes and proceeds to kick her, yell at her for a few minutes, and then leaves after that in her car. You hear about kind of stuff in third world countries, and you hear about the stuff over with, being burned by like acid and stuff like that. But this is, this is very up close and personal.
At her court appearance, she pleaded not guilty and was ordered to remain in custody without bail. The judge restricted media coverage of her in-court image, while some of her supporters described her as a community volunteer who regularly helped unhoused individuals with supplies. Authorities pointed to video evidence and witness accounts as key pieces in the case. Pop Ibara is scheduled to return to court later this month as legal proceedings continue. On July 1st, 2015, Kate Steinle was walking with her father when a single shot struck her, fatally wounding her. Authorities quickly arrested Jose Inez Garcia Zarate, an undocumented immigrant with a history of felony convictions and 5 previous deportations. He initially claimed he found the weapon wrapped in a cloth and that it accidentally fired. The weapon, a stolen federal agent's weapon, had discharged, and the bullet ricocheted before hitting Steinle. The case sparked national outrage, especially after it was revealed that San Francisco authorities had released Garcia Zarate from custody just weeks earlier, despite a federal immigration detainer. In November 2017, a California jury acquitted Garcia Zarate of murder and manslaughter charges, convicting him only of illegal firearm possession under state law. He was later indicted by a federal grand jury for being both a convicted felon and an undocumented immigrant in possession of a firearm.
Shame on the federal government. Shame on the Trump administration. Shame on them in terms of bringing a retaliatory, vindictive prosecution. He's being made a martyr to from my perspective, the racistic perspective of Trump.
Despite his defense attorney's claim that the federal charges were politically driven and retaliatory, on June 6th, Garcia Zarate was sentenced to time served, that is, 7 years, and ordered never to return to the U.S., with the judge citing his untreated schizophrenia and poor mental health care in custody. In April 2016, Ingrid Lyne, a 40-year-old nurse and mother of 3 from Renton, Washington, went on a date with John Charlton, a man she had met online and had been seeing for about a month. They attended a baseball game and later returned to her home. The next day, Ingrid's loved ones became concerned when she didn't respond to messages. When they visited her home, her belongings were inside, but she was missing. Shortly after, authorities discovered remains, which were later confirmed to be hers. Evidence found in her home, including cleaning tools and matching items, pointed to Charlton as a suspect. He was arrested and charged days later.
Mr. Charlton intentionally and with premeditation strangled Ingrid to death. He placed her body in a bathtub. Using a pruning saw, he dismembered her body, severing her limbs and head from her torso.
The loss of Ingrid Lyne remains a lasting wound for her family and community, particularly for her 3 daughters, who continue to live with the absence of their mother.
You smothered her laugh, you crushed her smile, and you left us with the nightmare of the unimaginable. Ingrid wasn't just murdered. Her body was brutally violated and discarded like she was nothing. She fought to live, and you forced her to die.
Our daughters continue to thrive, but miss their mother every day in different ways.
Charlton eventually pleaded guilty to first-degree murder and theft. During sentencing, he expressed remorse, although many, including the court, were skeptical of his account.
But he does hope that his decision to plead guilty as charged, his decision to actually make a statement as to what happened, that it answers questions for people.
I do agree that there are no words that can alleviate the pain that I've caused. And for that, I'm truly sorry.
Cowardly, you ran and hid, and when caught, you claimed you did not remember. Nobody believes that story.
Today is the close of a tragic end to a great life lived and ended far too soon.
The judge, deeply moved by the victim's impact statements and the nature of the case, imposed the maximum sentence allowed under Washington law, just over 27 years in prison. In March 2015, Officer Mark Collins of the Suffolk County Police Department initiated a routine traffic stop in Huntington Station. Among the passengers was 23-year-old Sheldon Lieutenant, an alleged gang member. When ordered out of the vehicle, Lieutenant fled on foot. Officer Collins gave chase and attempted to subdue him with a taser. During the struggle, Lieutenant pulled out a firearm and shot Collins. Miraculously, the injuries narrowly missed a major artery, and after a long recovery, Officer Collins returned to the job he loved.
I always dreamed of being a police officer, and I felt that I wasn't going to let someone take that away from me. And I wanted to get back to work as soon as I could, and that's what I did.
A year later, a jury found Lieutenant guilty of attempted aggravated murder and weapons charges.
My regards goes out to Mr. Officer Collins and his family. I guess the situation's out of hand. I lost the battle before I even fought it.
During sentencing in March 2016, he expressed regret but stopped short of taking full responsibility.
An attack on the police is an attack on all of us. The punishment must be severe.
Sheldon Lieutenant is innocent, and we will prove that in appeal. Sheldon Lieutenant did not have a fair trial.
Everyone basically bent over backwards to ensure that all his rights were guarded and that he received a fair trial. The evidence against Mr. Lieutenant was overwhelming.
The judge, citing the seriousness of the crime, sentenced Lieutenant to 55 years to life, the maximum allowed. While Lieutenant's family insisted he was framed and vowed to appeal, prosecutors stood by the conviction, calling the attack a direct threat to public safety and law enforcement. In July 2015, 20-year-old Daniel Rowe was fatally shot behind the Blind Rabbit Bar in Jacksonville, Florida, while taking out the trash during his shift. Authorities determined the killing occurred during a robbery that yielded only $4. For over 2 years, the case remained unsolved until Aaron Coleman was arrested and later pleaded guilty to second-degree murder. He admitted to being the shooter, claiming he intended only to scare Rowe. However, during initial proceedings, Coleman refused to reveal the identity of the accomplice who allegedly helped rob Rowe. A breakthrough came in 2017 when Coleman finally named Devontae Hanford as the second suspect. Hanford was soon arrested and charged with second-degree murder and armed robbery.
A huge range of emotions, really. It's kind of a roller coaster. Very happy. It's a good day. We have the other guy off the streets. Start of another journey through the court system, but we'll be there every step of the way. So grateful to everybody who's worked tirelessly to make this happen for us.
Rowe's family, who had waited years for closure, attended Hanford's first court appearance, expressing both sorrow and determination to seek justice.
I know in my heart in the end, he's going to be where he needs to be, and we're going to have justice for our son.
Do you plan on continuing to go to the hearings throughout all this?
Every single one. We will be there all the time. He's going to get to see us. He'll turn around and look at us just like Coleman did, and he's going to know who we are.
Meanwhile, Hanford's longtime girlfriend publicly denied his involvement, arguing Coleman's accusation was false.
I just believe it's all a big lie. He's not that type of person, and I don't think he had nothing to do with this.
And this man, Aaron Coleman, do you know who he is? Do you know why he's pointing a finger?
I've seen him, but I don't really know him like that. I don't know, maybe over some hatred, I don't know what, but I don't believe none of it.
Despite conflicting claims, the legal process moved forward, with both men ultimately pleading guilty. Coleman received a life sentence, while Hanford was sentenced to 20 years in prison, bringing a measure of closure to a case that had haunted the community for years. In October 2021, Jacksonville authorities were alerted to a disturbing scene in the Atlantic Boulevard Estates neighborhood, where witnesses reported seeing a man covered in blood wandering the streets before disappearing into nearby woods. Officers quickly responded, set up a perimeter, and located the individual, later identified as Yeri Noel Medina Ulloa. At first, he gave police a false name and claimed to be young. However, a later investigation by ICE and the Honduran consulate revealed he was actually 24 years old, and in the U.S., illegally. Following a trail of blood, officers discovered the body of 46-year-old Francisco Javier Cuellar inside a home on Lone Star Road. Surveillance footage from inside the home showed Medina Ulloa violently attacking Cuellar. A weapon with suspected blood was later recovered in the woods where Ulloa had been seen. In a text message to a witness, Medina Ulloa confessed, saying he had killed Uncle Francisco. He was arrested and charged with second-degree murder and tampering with evidence. In March 2023, he pleaded guilty.
These are middle-of-the-night flights, no notification to the state or anybody, and this is not the way you keep people safe. It's reckless and it's wrong.
Who confirmed that he, in fact, came here on one of these flights?
Yeah, we do not know exactly the source of that. There's some media reporting. Unfortunately, we're become very reliant on what's reported in the media as to what's happening with flights coming into Florida.
Who is helping them get on these flights?
Well, right now, that's what we're trying to find out. There's indications that private aircraft charter companies are involved with the aviation facet, that private bus charter companies are involved, and that there are non-governmental organizations, social support agencies, and so forth that are involved in the process.
The case sparked political attention, with Florida Governor Ron DeSantis criticizing federal immigration policies, claiming Ulloa had arrived in Jacksonville on a secret overnight flight. In 2023, Ulloa was sentenced to 60 years in prison, with an additional 5 years for the tampering charge to run concurrently. In April 2025, 55-year-old Angelia Solomon was arrested in Franklin, Tennessee, after she allegedly attempted to hire a hitman to kill her ex-husband. The supposed hitman was actually an undercover TBI agent who met with Solomon in a parked car at the Cool Springs Galleria. During the recorded conversation, Solomon said she wanted her ex-husband put under the ground, claiming he had abused her and their family, and even blamed him for their son's death in 2020.
He belongs to prison where he belongs. Under the ground, and I need
Agent Atkins. Agent Atkins, what was that last part of what we heard?
We were discussing what she wanted done, and in that portion of the audio, she said that she wanted him under the ground or in the ground.
She offered a vehicle registration as collateral and admitted she had no money but would pay in installments. Prosecutors later revealed that she had also provided specific details about her ex-husband's routine and vehicle, showing clear intent. After her arrest, Solomon was charged with solicitation of first-degree murder, a Class B felony.
Matter of the state of Tennessee versus Angelia Solomon, where she's charged with solicitation of first-degree murder, a Class B felony.
She pleaded not guilty during a preliminary hearing where the chilling audio was played in court. The judge reduced her bond to $250,000 and placed her under strict house arrest, banning her from using phones or the internet and limiting her movements to court appearances. She claimed her motive was to protect her family and denied financial gain. The case remains ongoing, with the next court hearing scheduled in July, and Solomon's bond conditions are being tightly enforced as the legal process unfolds. In May 2016, the body of 25-year-old Nikki Redden was found along a roadside in Baldwin, Florida. A beloved mother and the youngest of 7 siblings, her death shocked and devastated her family and community. Authorities launched a lengthy investigation, and months later, Dennis Mixon, who had previously served multiple prison sentences dating back to the 1970s, was linked to the case. In April 2018, Mixon was arrested and charged with first-degree murder and second-degree arson. He appeared stoic as he was wheeled into a Duval County courtroom, where he entered a not guilty plea. Prosecutors, citing the severity of the crime and Mixon's extensive criminal history, announced their intent to pursue the death penalty.
Our children, that's what's heartbreaking about this whole Nikki case. She was a great sister, she was a wonderful mother, and most of all, she was my dad's daughter, and she was the baby of 7 of us.
Happy-go-lucky. She had a heart of gold. She never met a stranger.
It's devastating, very devastating, but most of all, the justice is coming.
Redden's grieving family, wearing memorial shirts and standing in unity, vowed to be present throughout the court proceedings. They remembered Nikki as joyful, kind-hearted, and full of life, and remained committed to seeking justice in her name. In August 2015, Mitchell Daughtry was involved in a tragic incident that led to the death of his mother, Pamela Daughtry, inside their Arlington, Florida home. Shortly before the event, Pamela had texted her daughter expressing concern about Mitchell's anger and thoughts of self-harm. After the incident, Mitchell left the home and was later located in South Florida, driving his mother's car. Authorities took him into custody and transported him back to Jacksonville, where he was charged as an adult with second-degree murder, grand theft auto, and tampering with evidence. Initially pleading not guilty, Mitchell later changed his plea to guilty on the lesser charges. In 2019, now 18, he was sentenced to remain in a juvenile facility until he turns 21 for auto theft and tampering.
Is Mr. Daughtry before the court? We appear for the...
On to you, Mr. Daughtry. See you soon. See you in 2021.
The court deferred sentencing on the murder charge until he reaches adulthood. A mental health evaluation was scheduled 6 months before his 21st birthday. During his court appearance, his attorney shared that Mitchell had made significant progress in juvenile detention, nearing completion of high school. His family was present in court, offering support throughout the proceedings. No new developments in case have been reported yet. Laken Riley, a 22-year-old nursing student, began her day on February 22, 2024. Like many others, that morning, she sat in the living room of her shared home in Athens, Georgia, doing schoolwork on her iPad while chatting with her roommate, Connolly H., about their weekend plans. Around 8:45 a.m., Connolly left for class, leaving Laken behind. Shortly after, Laken got ready for her usual run. As she left the house around 9:03 a.m., Ring doorbell footage captured her wearing black Lululemon leggings, a tight black zip-up jacket, and white Hoka shoes, typical attire for her runs. Laken was an experienced and disciplined runner, often going for runs several times a week, sometimes covering distances of up to 6 miles. On that morning, she texted her mother around 8:55 a.m. to let her know she was heading out. A few minutes later, she began her run near the intramural fields of the University of Georgia. At approximately 9:11 a.m., her phone sent out an SOS alert and attempted a 911 call, which was disconnected. Data from her smartwatch showed her heart rate suddenly spiked and then declined, suggesting a possible attack. Her roommates began to worry when they hadn't heard from her by late morning. One of them texted to check if she was okay, but initially, there wasn't much concern. Laken often called her mom on runs and could be out longer than expected. That changed when Laken's sister tried calling Connolly twice. Unable to reach her, Connolly called back and learned that no one had heard from Laken. She then attempted to call Laken herself, but the call went unanswered. Alarmed, she contacted her other roommates and went to meet campus police at the intramural fields around noon.
I want to ask you, Ms. Huth, about February 22nd, 2024. Tell us about your morning that day.
I woke up, I had 2 classes that day, so I woke up at 7:45. I quickly got ready and I had class at 9:35 and 11:10 in Caldwell Hall in the same room. As I got ready, I walked out to our living room and kitchen. Laken was sitting there with her iPad and she was taking notes and doing her homework and watching Netflix. And for 45 minutes, we sat and talked about our plans for the weekend and what we were going to do later that night. And I left for class at around 8:45 to get on the bus.
When you left for class, was Laken still in the house?
Yes.
And at some point when you were in class, did you become concerned about Laken?
Yes.
Tell us why and what happened.
At one point, Lily had sent a text asking if Laken was okay. And I was in class and I just figured she was on the phone with her mom and walking around because that was standard. And I didn't think anything of it. And then at around 11:15, 11:20, I got a call from Lauren, Laken's sister, and I didn't answer because I was in class. And then she called me again and I didn't answer. And I texted her and I said, like, I'm in class, what's up? And she asked me if I'd heard from Laken. And I immediately went into panic. I stepped outside of the class and I called Lauren back and said I'll try to figure out what's going on. So I then called my two roommates, and both of their phones went immediately to voicemail. And then I tried calling Laken and her phone rang and then went to voicemail.
Why were you panicked immediately?
Just because she would run for a long time, but I knew she had class that day, and I knew that she wasn't one to be late or off schedule.
All right. So, at some point, did you meet up with the University of Georgia police officers?
I did.
When did you do that, and where were you?
I had Sophia pick me up from my class around 12:15, 12:20, and she took me straight to the intramural fields to meet with the officer and Lily.
How long did y'all stay there that day?
6 hours, 7 hours.
When was your last communication with Laken Riley?
9 o'clock.
At what day?
On February 22nd.
Okay. Did you ever hear from her after that?
No, I did not.
May I have one moment, Your Honor?
Yes.
At 12:38 p.m., University of Georgia police discovered Laken's body roughly 65 feet off the trail. She had been brutally attacked, suffering multiple injuries and showing signs of strangulation. Her phone was found nearby, discarded. DNA under her fingernails and on a jacket linked the crime to Jose Antonio Ibarra, a 26-year-old Venezuelan who had entered the U.S. illegally in 2022. His fingerprint was also found on Laken's phone. He was arrested the following day and charged with malice murder, felony murder, aggravated assault with intent to rape, kidnapping, obstruction of a 911 call, and peeping Tom offenses. In May 2024, a grand jury indicted Ibarra. He waived his right to a jury and pleaded not guilty. His bench trial began in November. Prosecutors presented a strong case based on digital, forensic, and surveillance evidence. The defense attempted to challenge the reliability of the DNA and phone data, but failed to convince the judge.
You may have seen me, I made notes during the trial. I probably filled up 2 legal pads full of notes during the trial, but the closings, I want to just listen, and that's what I did. But I wrote down 2 things in the closing. One was a statement by Ms. Ross that the evidence was overwhelming and powerful. And then I also wrote down what Ms. Beck said, that I'm required to set aside my emotions. That's the same thing that we tell jurors in what, and we're giving them their job. I would, that's the way I have to approach this. And I did. Both of those statements are correct. I'll now announce the verdict. In the state of Georgia versus Jose Antonio Ibarra, case SU 24CR0323, count 1, malice murder. I find the defendant guilty. Count 2, felony murder. I find the defendant guilty. Count 3, felony murder. I find the defendant guilty. Count 4, felony murder. I find the defendant guilty. Count 5, kidnapping with bodily injury. I find the defendant guilty. Count 6, Aggravated assault with intent to rape, I find the defendant guilty. Count 7, aggravated battery, I find the defendant guilty. Count 8, obstructing or hindering a 911 call, I find the defendant guilty. Count 9, tampering with evidence, I find the defendant guilty. Count 10, peeping Tom, I find the defendant guilty.
On November 20th, 2024, Jose Ibarra was found guilty on all counts.
Oftentimes, people use the term closure at an event like this, and I acknowledge that there's no such thing as closure. There will not be closure. This is just another stage or event in this tragedy, and that's the way I view that. People mean well by saying that, but it's. I've heard it explained that when you have something like this that impacts one or many, you even have to make a conscious effort to breathe at sometimes. And that just comes on you at any particular, you just don't know what's going to bring it on you. And you realize that you do make it through the day, but you don't know how you did it. But I also, and this goes back to what Carrie Howell was saying, that, as many times as you reflect on the loss, at some point you start smiling about the memories, and I'm hopeful that at some point that takes over to a certain extent. But there's very little, including the sentence of Mr. Ibarra, that's going to help much, and I acknowledge that. With that, Mr. Ibarra, if you will please stand. Count 1, malice murder. I sentence you to life without the possibility of parole. Count 2 will be vacated as a matter of operation of law. Count 3, vacated by operation of law. Count 4, vacated by operation of law. Count 5, life in prison consecutive to count 1. Count 6, 20 years to serve consecutive to count 5. Count 7 will merge with count 1. Count 8, 12 months consecutive to count 6. Strike that. 12 months, but I don't want it to 6. It's just going to be consecutive. Count 9, 12 months consecutive. Count 10, 5 years consecutive to count 6. So that would mean the misdemeanors would come after the felonies. That would be the sentence.
He was sentenced to life without the possibility of parole, along with additional consecutive sentences for related charges. Since then, he has remained incarcerated at Georgia Diagnostic and Classification State Prison. The case sparked national debate over immigration policy and campus safety. In response, the U.S. government passed the Laken Riley Act, which mandates detention for undocumented immigrants charged with certain crimes. A memorial has been created in Laken's honor, and her family has established a foundation to carry forward her legacy. As of June 2025, the sentence remains in place, and there have been no successful appeals. On June 14, 2018, in Westminster, Colorado, Megan Bigelow was driving her 3 sons, Vaughn, Cooper, and Asa, to a dentist appointment. While traveling on Sheridan Boulevard, she changed lanes to yield to an emergency vehicle. This maneuver angered the driver behind her, Jeremy Webster, who began yelling at her. Instead of letting it go, he followed the Bigelow family into the parking lot of the Cedarwood Square office complex, where their dental office was located. Once parked, Webster stepped out of his car, approached the family, and opened fire. Vaughn was killed. Megan and her youngest son, Asa, were seriously injured. A Good Samaritan named John Gale, who tried to intervene, was also wounded. Cooper narrowly avoided injury. After the shooting, Webster drove away, stopped briefly at a nearby store, and then continued on to a job site. Later that same day, police tracked him down and arrested him near Castle Rock. He was charged with first-degree murder, multiple counts of attempted murder, and first-degree assault. Webster pleaded not guilty by reason of insanity, claiming mental instability at the time of the shooting. His first trial, held in 2021, ended in a mistrial due to procedural issues. A second trial took place in 2023 at Adams County District Court. During 2.5 weeks of testimony, the jury heard from survivors, experts, and law enforcement. A court-appointed psychiatrist concluded that Webster was legally sane when he committed the attack. Megan Bigelow provided powerful testimony about what happened that day and how it affected her family.
So as to the first verdict form, People of the State of Colorado v. Jeremy Webster, jury verdict, charge of murder in the first degree. After deliberation, Part A, we the jury find the defendant, Jeremy Webster, guilty of murder in the first degree after deliberation. People of the State of Colorado v. Jeremy Webster, jury verdict, charge of attempt to commit murder in the first degree. After deliberation, Megan Bigelow, we the jury find the defendant, Jeremy Webster, guilty of attempt to commit murder in the first degree. After deliberation, we further find with respect to the verdict questions for this court as follows. 1, did the defendant cause serious bodily injury or death? Answer, yes. 2, did the defendant use or possess and threaten the use of a deadly weapon? Answer, yes. Obviously, Part B was left blank on both of those verdict forms. People of the State of Colorado v. Jeremy Webster, jury verdict, charge of attempt to commit murder in the first degree. After deliberation, Cooper Bigelow, Part A, we the jury find the defendant, Jeremy Webster, guilty of attempt to commit murder in the first degree after deliberation. We further find with respect to the verdict questions for this count as follows. Did the defendant use or possess and threaten the use of a deadly weapon? Answer, yes. Part B is left blank. People of the State of Colorado v. Jeremy Webster, jury verdict, charge of attempt to commit murder in the first degree. After deliberation, Asa Bigelow, Part A, we the jury find the defendant, Jeremy Webster, guilty of attempt to commit murder in the first degree after deliberation. We further find with respect to the verdict questions for this count as follows. Did the defendant cause serious bodily injury or death? Answer, yes. Did the defendant use or possess and threaten the use of a deadly weapon? Answer, yes. Part B is left blank. People of the State of Colorado v. Jeremy Webster, jury verdict, charge of attempt to commit murder in the first degree. After deliberation, John Gale. Part A, we the jury find the defendant, Jeremy Webster, guilty of attempt to commit murder in the first degree after deliberation. We further find with respect to the verdict questions for this count as follows. Did the defendant cause serious bodily injury or death? Answer, yes. Did the defendant use or possess and threaten the use of a deadly weapon? Answer, yes. Part B is left blank. People of the State of Colorado v. Jeremy Webster, Jury verdict, charge of attempt to commit murder in the first degree, extreme indifference, John Gale. Part A, we the jury find the defendant, Jeremy Webster, guilty of attempt to commit murder in the first degree, extreme indifference, John Gale. We further find, with respect to the verdict questions for this count, as follows. Did the defendant cause serious bodily injury or death? Yes. Did the defendant use or possess and threaten the use of a deadly weapon? Yes. Part B is left blank. People of the State of Colorado v. Jeremy Webster. Jury verdict, charge of attempt to commit murder in the first degree, extreme indifference, Harlan Gale. Part A, we the jury find the defendant, Jeremy Webster, guilty of attempt to commit murder in the first degree, extreme indifference, Harlan Gale. We further refined, with respect to the verdict questions for this count, as follows. Did the defendant use or possess and threaten the use of a deadly weapon? Answer, yes. Part B is left blank. People of the State of Colorado v. Jeremy Webster, charge of assault in the first degree, Megan Bigelow. Part A, we the jury find the defendant, Jeremy Webster, guilty of assault in the first degree, Megan Bigelow. Part B is left blank. People of the State of Colorado v. Jeremy Webster, jury verdict, charge of assault in the first degree, Asa Bigelow. Part A, we, the jury, find the defendant, Jeremy Webster, guilty of assault in the first degree, Asa Bigelow. Part B is left blank. People of the State of Colorado v. Jeremy Webster, jury verdict, charge of assault in the first degree, John Gale. Part A, we, the jury, find the defendant, Jeremy Webster, guilty of assault in the first degree, John Gale. Part B is left blank. People of the State of Colorado v. Jeremy Webster, jury verdict, charge of assault in the first degree, extreme indifference, John Gale. Part A, we the jury find the defendant, Jeremy Webster, guilty of assault in the first degree, extreme indifference, John Gale. Part B is left blank. People of the State of Colorado v. Jeremy Webster, jury verdict, charge of attempt to commit assault in the first degree, extreme indifference, Harlan Gale. Part A, we the jury find the defendant, Jeremy Webster, guilty of attempt to commit assault in the first degree, extreme indifference, Harlan Gale. Part B is left blank.
On April 26, 2023, the jury found Jeremy Webster guilty on all 12 counts. These included first-degree murder for Vaughn's death, attempted murder for the attacks on Megan, Asa, Cooper, and John Gale, and several assault charges. The jury confirmed that he used a deadly weapon and caused serious harm. Judge Priscilla Lowe sentenced Webster to life in prison without the possibility of parole, along with additional decades behind bars for the other charges. Following the verdict, Megan Bigelow expressed a quiet sense of closure, acknowledging that justice had been served, though it could never bring her son back. On January 15, 2020, 19-year-old Mubarak Solomon, who was reportedly experiencing a mental health episode, was involved in a carjacking in Norwalk, Connecticut. After fleeing the scene in a stolen vehicle, he led state troopers on a high-speed chase down Interstate 95, reaching speeds up to 100 miles per hour. The pursuit ended in West Haven, where police boxed in the vehicle under an overpass. Solomon remained in the driver's seat with the doors locked when an officer shattered the passenger side window. Solomon suddenly displayed a large kitchen knife. At that moment, Connecticut State Trooper Brian North, positioned near the driver's side, fired rounds through the closed window, striking Solomon. Solomon died at the scene. The incident sparked immediate public scrutiny, especially as body cam footage emerged showing the moments before the shooting. Civil rights advocates and Solomon's family argued that the boy, who had schizophrenia and bipolar disorder, posed no immediate threat once the vehicle was contained. North maintained he believed his fellow officers were in danger and that his actions were necessary to protect them. After a lengthy investigation, Trooper North was charged in April 2022 with first-degree manslaughter with a firearm. He pleaded not guilty in June of that year. The charge accused him of acting with extreme indifference to human life. The case proceeded to trial in February 2024 in Milford Superior Court. Jurors heard from medical experts, law enforcement officials, and Solomon's family. Prosecutors argued argued that North had alternatives to deadly force, and that firing rounds at a confined individual with mental illness was reckless and unjustified. The defense insisted that North made a split-second decision to prevent potential harm to others. After nearly 2 weeks of testimony and several days of deliberation, the jury returned a verdict in March 2024.
So we have a note again. It's Court Exhibit 12. Note reads, "We have reached a final decision of this case," signed by the foreperson. If you'd like to see it, it's...
No, thank you.
Okay. Anything before I bring in the jury?
No, Your Honor.
Okay. Could we bring the jury? Please be seated. Mr. Clerk.
Ladies and gentlemen of the jury, as your initials are called, please answer here. Rise and remain standing. Initials SF.
Here.
Initials JH.
Here.
Initials RH.
Here.
Initials AC.
Here.
Initials TS.
Here.
Initials MD.
Here.
Ladies and gentlemen of the jury, in the case of State of Connecticut v. Brian North, have you agreed upon a verdict?
Yes.
Will the defendant Brian North please rise? Will the foreperson of the jury identify himself or herself by stating your initials for the record?
RH.
Mr. Foreperson, will you remain standing? The remaining members of the jury may be seated. In file number AAN CR2201215880T, State of Connecticut v. Brian North, what say you, Mr. Foreperson? Is he guilty or not guilty on the first count of the crime of manslaughter in the first degree with the firearm, in violation of Section 53A, 55, paren A, paren 3, and Section 53A, 55A of the Connecticut General Statutes, with which he stands charged?
Not guilty.
In file number AAN CR2201215880T, State of Connecticut v. Brian North, what say you, Mr. Foreperson? Is he guilty or not guilty of the lesser included offense of manslaughter in the second degree with the firearm in violation of Connecticut General Statutes 53A, 56, paren A, paren 1, and 53A, 56A, with which he stands charged?
Not guilty.
And file number AAN CR2201215880T, State of Connecticut v. Brian North, what say you, Mr. Foreperson? Is he guilty or not guilty of the lesser included offense of criminally negligent homicide in violation of Connecticut General Statutes 53A, 55, with which he stands charged?
Not guilty.
Does the court accept this verdict?
Yes.
The jury may be seated. Ladies and gentlemen of the jury, please listen to your verdict as it is accepted in order recorded by the court. You, ladies and gentlemen of the jury, each of you do say unanimously that the defendant is not guilty of the crime of manslaughter in the first degree with the firearm in violation of Section 53A, 55, paren A, paren 3, and Section 53, 55A of the Connecticut General Statutes as outlined. You, ladies and gentlemen of the jury, each of you do say unanimously that the defendant is not guilty of the crime of the lesser included offense of manslaughter in the second degree with the firearm in violation of Connecticut General Statutes 53A, 56, paren A, paren 1, and Section 53A, 56A of the Connecticut General Statutes as outlined. You, ladies and gentlemen of the jury, each of you do say unanimously that the defendant is not guilty of the lesser included offense of criminally negligent homicide in violation of Section 53A, 55 of the Connecticut General Statutes as outlined. Mr. Foreperson, is this your verdict?
Yes, it is.
Ladies and gentlemen, is this your verdict? So say you all?
Yes.
Yes.
Thank you, Your Honor.
Would either of the parties request that the jurors be polled?
No, Your Honor. No, Your Honor.
All right, then. Your work is done here. You have the thanks of the state of Connecticut and the court and the parties. This was a difficult case. The work that you did was hard. And like I told you in the first place, you won't ever forget it. So you are discharged. Your jury service is complete. I would ask that if you could remain in the room behind here for a few minutes, because I'd like to speak. You're excused. Anything from counsel?
Not from the state, Your Honor. Not from the defense, Your Honor.
All right. Sir, you have been acquitted. You are discharged. Do we have anything else we need to do here?
No, Your Honor.
All right. Then we are adjourned.
Not guilty on all charges. While North was cleared of criminal wrongdoing, the verdict was met with deep disappointment from Solomon's family and advocates for police accountability. In the months following the trial, the state of Connecticut reached a financial settlement with the Solomon family over a related civil lawsuit. However, legal proceedings continue against the city of West Haven as questions remain about shared responsibility and law enforcement protocols during the arrest. As of now, Brian North remains employed by the Connecticut State Police. In September 2021, a tragic shooting took place at Club Cream in Greenville County, South Carolina. Elijah McDuffie was shot and killed during the incident. The Greenville County Sheriff's Office quickly launched an investigation and identified 22-year-old Aaron Messiah Hoderi Harper as the suspect. Authorities believed that Harper and McDuffie knew each other, though the exact motive behind the shooting was not made public. Shortly after the incident, Harper was located and arrested in Greenwood, South Carolina. He was then transferred to the Greenville County Detention Center to face charges of murder and possession of a weapon during the commission of a violent crime. During a bond hearing, Harper appeared before a magistrate judge.
Mr. Harper, again, you charged with murder and possession of a weapon during the commission of a violent crime. Sir, you've been charged with a criminal offense, and if you're found guilty, you are facing serious consequences, which may include the payment of a fine, loss of your driver's license, and the possibility of a jail sentence. In addition, sir, you may face increased penalties for later convictions, the loss of your right to possess firearms and ammunition, and your immigration status could be affected. Sir, you have important constitutional rights, including the right to representation by an attorney, but you may lose these rights or waive them if you do not act to protect them. You have the right to hire an attorney to represent you in every case. If you cannot afford an attorney, you may be eligible for a free attorney. If you want determination made as to whether you are qualified for a free lawyer, then it is your obligation to be screened at the location identified in paragraph 5C of the bond checklist form that we'll be giving you today. If you not hire an attorney to go be screened, sir, you may be found to have waived your right to an attorney to trial. Mr. Harper, you also have the right to represent yourself, sir. However, you should be aware that self-representation can be dangerous. For example, there may be certain factual or legal defenses to your charge that you are not aware of, or legal issues related to the conduct of your trial or guilty plea that an attorney would know how to preserve for an appeal. If you exercise your right to proceed without a lawyer, then you, sir, are responsible for complying with all the applicable rules of the court, including rules of evidence, procedural rules, and proper behavior before the judge and the jury. If convicted on the charges filed against you today, sir, and ought to pay a fine, you may request a reasonable scheduled payment plan from the court. Again, Mr. Harper, it is your obligation to keep up with your trial date to obtain an attorney, either by hiring one or being screened and found eligible for a court-appointed attorney prior to your trial date. If you not appear at trial with your attorney, sir, you may deem to have waived your right to have an attorney represent you. It's your responsibility, sir, to keep the court notified if you should move or change address. Again, sir, you have a right to remain silent, the right to an attorney, and the right to a trial by jury. Do you know what a preliminary hearing is, sir?
No, ma'am.
A preliminary hearing is a probable cause hearing. That's a hearing to determine if there was sufficient probable cause to issue the warrants against you today, sir. That is not an automatic hearing. You must request a preliminary hearing. We will be giving you a preliminary hearing request form today. You have 10 days to complete and mail that form in. If you fail to turn it in a timely manner, you may not be given a preliminary hearing on your charges. The public defender's address is 305 East North Street, And I have the information, and you can write them if you like to. If you found indigent, they may waive the fee for you or reduce it. And again, if the charges that have been brought against you today is discharged, dismissed, nor processed, if you're found not guilty, you may have your record expunged. And you have a right and obligation to be present at a trial, and the trial may proceed in your absence if you fail to appear in court.
The judge explained the seriousness of the charges and the possible consequences if convicted, including prison time, fines, loss of firearm rights, and potential impacts on immigration status. A deeply emotional moment came when a member of Elijah McDuffie's family addressed the court. Through tears and pain, she tried to express her sorrow, reflecting the heartbreak caused by the loss.
Thank you. Is there anything you'd like to say today, ma'am?
Harper, when given the opportunity, chose not to make a statement.
Thank you so much. Mr. Harper, gonna hold you with that bond on both your charges. I do not have the authority to set bond today. A circuit court judge can set bond. You can get an attorney to petition circuit court judge for a bond hearing, but right now we're gonna hold you with that bond. Thank you so much, sir. Thank y'all so much. If you'll step down, we'll let you sign your document.
Because of the severity of the charges, the magistrate judge did not have the authority to set bond. Harper was ordered to remain in custody until a circuit court judge could consider a formal bond request. As of now, Aaron Harper remains jailed with no bond set. His case is expected to proceed to circuit court, where future hearings or a potential trial will determine the outcome. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.